And now we'll invite Myles McGregor-Lowndes, and he's going to talk to us about donor expectations. Myles?
Thank you. My very best wishes to you all during this time, and I hope you're all safe. With the first slide, please. The second slide. I'll start. Thank you. The very first civil case heard in Australia was all about donor expectations and respecting donor issues, and it stands as a yardstick for us today. In 1783, 18-year-old Henry Cable was convicted in Norfolk of burglary and sent to Norwich Castle Prison. He met Susanna Holmes, also a petty thief, and they had a child in prison. Both were under sentence of death, but it was commuted to transportation to the Americas. When this became impossible because of the revolution, they were sent on the first fleet to Sydney. Susanna and child were rowed out to a prison hulk to await transportation by their jailer, John Simpson, only to have the ship's master refuse the child as it was not on his manifest. As the story goes, next slide please, Simpson took this child immediately by carriage to London and to the Home Office, where he got no joy from the clerks. He finally bailed up Lord Sydney in a foyer and convinced him to order the reunification of the baby and the mother, as well as the father, on the first fleet. The story made the newspapers and circulated very widely in England. Transportation to Australia was not publicly popular. It was akin to sending prisoners to Mars, never to have them to return. Next slide, please. Donor emotion demanded a quick response, and even without a Facebook donor button, the 1700s crowdfunding appeal swept the nation. Newspaper gossip columns recorded who gave and how much. Does this remind you of anything? The funds were converted to 25 pounds weight of goods for the baby, such as clothes, and were placed on the first fleet ship, the Friendship. Next slide, please. At Sydney Cove, Henry Cable and Susanna Holmes were married by the chaplain, Richard Johnson, on the 10th of February, 1788. Theirs was the third Christian marriage in Australia. Johnson asked about the baby and where the package was. The couple hadn't been able to recover their baggage, and the cleric undertook to investigate. It could not be found, and the master of the Friendship was very uncooperative. An action was begun. Pleadings were drawn and signed by the Cables through their marks. They were illiterate. The pleadings can still exist to this day in a New South Wales library. The first civil court, consisting of Collins, the judge advocate, Johnson, the chaplain, and White, the surgeon, assembled on the 1st of July, the same day that the plate was dated. They did not consider the conflicts of the three themselves as they probably drafted the plate, nor whether convicts had standing to sue in their court. However, compensation by the master was quickly ordered. The newspapers record Johnson as writing, "I'm sorry this charitable intention and action has been brought to this disagreeable issue, the more so because the public seem to be so much interested in their welfare." I'll just throw in some social impact. Cable was made constable, then chief constable, and later a ship owner of a fleet of 25 merchant ships, was a brewer, and played a notable role in the early economic history of the colony. Next slide, please. I've got no time to go through any further legal history, but do point you to the words of Lord Harmon in 1958. They are still true. Still today, many humans seek the warm inner glow of a gift giving in a disaster appeal and leave all rational thought to one side. In that case, a bus accident involving 23 young cadets who were killed on a foggy London night being run over by a double-decker bus. 3 mayors made a newspaper appeal for funds for the funeral expenses. They raised 9,000, spent only 2,000. The bus companies and its insurers paid generous compensation for all the funerals. It was not regarded as charitable. What happened to the surplus? It's an instructive case about the legal principles in such situations. Next slide, please. The emotional response to a disaster has not waned over the decades, and Australia has legislative fixes for this. New South Wales and Queensland have disaster relief funds which deal with the issues. The legislation is dated like most fundraising regulation in Australia and doesn't deal with social media appeals. Overseas jurisdictions have done better and are now designing new regulations, particularly for mid-appeal change of purpose, as may have occurred in the Celeste Barber Facebook appeal. In Canada, they've had another bus accident case where they test ran the model laws developed by the Uniform Law Conference. It's being revised now again in light of that case. The US Attorney Generals, as Christian has suggested, have done a report on PayPal giving, and they are now drafting model laws for states to consider implementing. That brings me to the recent bushfires. Next slide, please. What were the donors' expectations? Just by coincidence, there was a public survey done of some 957 respondents at the end of the Celeste Barber appeal. 51% of the 957 stated they had made a donation to the bushfires. 64 of those stated that they had donated to Facebook. And what I've done is next slide please, is cut out those 64 and some of the answers that they gave to their questions. This first one, they were asked to rank the top 3 reasons why they donated. And you can see up the top of communities impacted by the fires, but also volunteer firefighters. Blue is number 1 choice, and the orange is the top 3 choices combined. Next slide, please. And the next slide asks the question of what they expected to happen. And so you can see that there are some slight differences there. Next slide, please. Now, for those who said that they donated to the Facebook appeal and stated that they wanted to help firefighters, what did they actually want to do? And here we have their answers. Again, trying to draw out some unified purpose is difficult. Next slide, please. I throw this one in gratuitously. There is clearly an expectation gap between what donors want and when they want it done and what charities can do in reality. They wanted it spent in the next couple of weeks. Again, a really difficult expectation gaps that charities have got to address. Next slide, please. So this brings me to the court. There is a paragraph in His Honour's decision which says that maybe there's a donation impressed with a charitable purpose other than that provided by the terms of the PayPal Giving Fund or the RFS Fund. The Attorney General also submitted that the court should consider making such a statement so as not to prejudice the rights of any settler. There are some really interesting and complex legal questions raised here. Can we find evidence of a donation impressed with a charitable purpose here over and above the PayPal terms? Are they just statements of preference or direction? Next slide, please. You can have a look at the posts and they vary. There are just literally thousands of them to go through. Hours of fun for every lawyer. Do we just look at the construction of the deed and not the subjective intention as Barnes and Kendall in the High Court suggested? Is there the issue of mistake in establishing the charitable trust? Not often we hear of mistake in contract law, but not trust law. Pitt and Hollis, does that apply? And then there's, next slide please, there's the whole issue of what are the terms of the trust. Here we have the Facebook page post that found. There are different screens. Next please. Here's what I bring up today on my screen, and you can see it's different. It's different from a mobile screen, from a desktop screen. The court used the mobile screen. There's some really interesting issues, next screen please, that I haven't got to the bottom of. The court seemed to accept that there was a click-wrap contract. My view, looking at my screen, is that what we have here is a learn more, under learn more, is a browse wrap. And you have to go to a policy page and then go to an article, and then there's no donor sub-page, and then 3 clicks you finally get to the terms and conditions of PayPal. It is extraordinarily difficult, and quite a few of you on this on this Zoom cast who have asked to find it are still looking for it. So I think there's an issue there that I'd like to further investigate. On the final slide, please. Some recommendations. Here are my recommendations. Authorisation by the charity to fundraise on their behalf for cyberspace collections. New South Wales and Queensland requires authorisation by law for public collections on behalf of a charity. It's good practice, even if it isn't law, for charities, so they can risk manage fundraising stunts done in their name. It's another step for online platforms, which is ridiculously easy to create fundraisers. But I would like to see that a charity, even though they've signed up for PayPal, ought to be able to approve or disapprove people collecting on their behalf, and the charity can and be obliged to intervene to stop appeals that become inappropriate. I think we need fit-for-purpose fundraising regulation, not necessarily legislation. We need to revamp the disaster statutes as they're doing in North America. And I acknowledge Sue Woodward here and go to the fundraising, fixed fundraising page. I also think that the ACCC should be active in donor protection. Fraud, certainly, misleading or deceptive conduct. And if you've had a look at some of the terms in the PayPal giving, then I think, you know, they're trying to get indemnities out of donors and all sorts of things. I think only terms reasonably necessary to protect the legitimate interests of the party advantaged by the term should be contemplated. Thank you.
Thank you very much, Myles. Yes, layers and layers of terms and conditions, and learn more as you keep clicking through. That was my experience too.